Hi, I'm Jing. My metric number is 276/7.
My name is Lin Hui Wen, metric number 279005.
Good day, doctor. My name is Ho Kai Man, metric number 279215.
I am Subashini Gopalakrishnan with metric number 280435.
Hi everyone, my name is Lizika and my metric number is 281751.
What is constitutional crisis? Constitutional crisis is an issue or dispute in a government's role that the democratic constitution or other basic governing law is unable to address. In 1988, Malaysia countersigned some significant events. Constitutional Crisis 1988 began with United Malaysia National Organisation, which is also known as UMNO, party elections in 1987. Not only was the governing party declared an unconstitutional society by a High Court judge, which also resulted in executive intervention with the judiciary culminating in the dismissal of the country's most senior judge, the Lord President of the Supreme Court, and two other Supreme Court judges. Now, let's see the timeline of Constitutional Crisis 1988. The Constitutional Crisis 1988 started in January 1973. Tun Saleh Abbas as a public prosecutor successfully appealed to increase Tengku Mahmud Iskandar's conviction for hurting civilians. In February 1984, Tengku Mahmud Iskandar became the 8th Yang di-Pertuan Agong of Malaysia. In April 1987, UMNO leadership elections was held. In October 1987, which the beginning of Oops Lalang, which saw the arrest of Tun Mahathir's political opponents and critics under the Internal Security Act. In February 1988, High Court declared that UMNO was an illegal society and UMNO was officially deregistered. In March 1988, Tun Mahathir tabled a constitutional amendment in the Dewan Rakyat. In May 1988, Tun Saleh Abbas was removed from the position as Lord President. Tan Sri Hamid Omar became the acting Lord President. In June 1988, the constitutional amendment that would limit the powers of the court came into force. In July 1988, High Court heard Tun Saleh's application for leave to seek an order of prohibition to prevent the tribunal from submitting its report to the YDPA. The Supreme Court had set aside the interim order granted by the 5 judges, and finally the tribunal report was submitted to the YDPA. In August 1988, Tun Saleh was officially removed from the office. And finally, in September 1988, the second tribunal to hear the charges against the 5 Supreme Court commenced. All 5 judges were accused of convening and hearing a case without prior permission from the acting Lord President and heard a case that has yet to be decided in the High Court. That was the end of the Constitutional Crisis 1988.
The conflict between the government and the judiciary. In the case of J.P. Preferson versus Director General of Immigration Malaysia, the plaintiff was served a notice of cancellation of his employment pass under the Immigration Regulation 1963 by the immigration authorities. It was on the grounds that he wrote and published an article in the Asian Wall Street Journal. The article covered the chronism in banking and economic mismanagement in Malaysia. Subsequently, he had filed a petition for writ of certiorari and prohibition in the High Court against the cancellation of his employment pass and the removal from the country. Unfortunately, it was rejected. Soon, an appeal had been lodged to the Supreme Court on behalf of him. Yusufir Abdul Kadir, Supreme Court judge, adjudicated that he was lawfully to stay in Malaysia under the stipulated periods of his employment pass on the application of natural justice. The Prime Minister dissented about this case. He said that it was furious about enacting a law if the interpretation goes otherwise. Enacting a law to be interpreted based on their wish is a need.
And now I will further elaborate on the result of conflict between the government and judiciary by referring to the case of public prosecutor against Dato' Yap Peng in the year 1987. In this case, Dato' Yap Peng was being charged with criminal breach of trust in session court. The deputy public prosecutor presented a certificate requiring the lower court to transmit the case to High Court as according to Section 418A of the Criminal Procedure Code. However, when the case was transmitted to the High Court, this section was being opposed or rejected as unconstitutional on the ground that it was contradicted with the Article 121, Clause 1 of the Federal Constitution. The result of this conflict that will be discussed is on how the executive interferes with power vested upon the judiciary and how it limits the power of the judiciary as well as cause lack of judicial independence within them. This will be further elaborated in the next slide.
And today I will present on the removal of Supreme Court judges. The first charges found on Tun Saleh Abbas' tribunal report is that he gave public speeches attacking the executive and commenting on the remarks of judicial independence, comments delivered by the Prime Minister. And the second charges found on Tun Saleh Abbas' tribunal report is that he argued that inadequate fundings gave to the courts to perform their actions properly. And the third charges is because Tun Saleh Abbas he itself adjourns the appeal in the case of Teo Eng Huat, which concerns a minor choice of religions. And the fourth charges is because he wrote a letter to the king, attempting to involve the king in conflict with the executive and accusing the prime minister of destroying the judicial independence. And the final charges is because he made various public statements, politicized the issues of his suspensions, causing the disruptions to the public order and national interest. And after that, I will explain on the 5 judges' tribunal report. We know that in the finals, only 2 judges were removed from their office and the 3 remains in their office. And the 2 offences committed by the 3 judges is that they willfully present at the Supreme Court hearing and convening without the knowledge and permissions of the acting Lord Presidents. And the second is that they without adhering to the proper procedure by willfully hearing the case still being heard by the Ajab Singh's judges. And the third offence is committed by the 2 removal of judges, that is Wan Sulaiman and George Sia, that is they fail to perform their functions at the Kota Baru Supreme Court sittings. And the fourth offences committed by them is that Wan Sulaiman ordered the George Sia and Harun Hashim to leave their duties at their sittings without a good and valid reasons.
Today I'm going to present the cases of judicial adjudication. Since 1988, judicial crisis is a complex web of power play on the part of those attempting to consolidate power and control. Following the government period in public prosecutor against Dato' Yao Peng, Article 121, Subsection 1 was amended to dispose any prerogative authority from the judiciary in order to monitor the executive. This amendment also controversially rejected the opinion expressed in this judgment that judicial power are solely judiciary. Numerous offer rulings, such as the one in the Persatuan Aliran Kesedaran Negara against the Minister of Home, were riddled with excessive prejudice in favor of the government. At the same time, Article 101, Subsection 1 was ordered to deprive the judiciary authority of the constitutional system, esteemed that instead with such judicial powers as legislative may provide. After the fires, the judiciary has seen a renaissance in landmark cases such as Semai Jaya and Indira Gandhi. According to the judgment in Semai Jaya's case, the fundamental principle of judiciary authority, judicial independence, and separation of powers are all as a basic to the constitutional system as they are holy. Unfortunately, the federal court seems to have gone backwards in Letitia Bosman's case, in which the judges claimed that the notion of separation of power had been violated. Each of the 3 branches of government must respect the authority of the others. The judiciary must adhere to Parliament's privilege. A judicial ruling that contradicts the Parliament's legitimate power would upend the rule of justice. It is necessary to maintain the federal court's balance. Thank you.
In the events of 1988, the representations made by the Prime Minister to remove the Lord President was deemed to be motivated by his political interests. Throughout the investigations, there were controversial decisions made. The intrusion of the executive and judiciary had affected its impartiality and independence, and at the same time, the public confidence. To restore the public confidence towards our judiciary, the sole power of the Prime Minister to recommend the appointments of Chief Justice and also other judges of superior courts should be removed. This authority should be vested on a body that is independent of politics and the executive to ensure the impartiality in its recommendations. Furthermore, the appointment of judicial commissioners in Malaysia should be abolished, as the independence of a judicial commissioner from any personal interest and consideration is questionable.
Next, I'm going to discuss regarding the need for judicial adjudication. Jurisdictional calamity in 1988 triggered a massive setback to the Malaysian court's functional uprightness and society's conviction in the nation's lawful scheme and governmental organization. The Malaysian judges have made a great effort to recapture the community's level of certainty in the country's statutory procedure through the judicial crisis 1988, emerging a legitimate judgment method for Malaysian constitution in a way exact to its underlying doctrines, and vital undertaking would be an overwhelming momentous move for Malaysian judges in its way on the pathway of statutory restoration. In other words, the Malaysian judges should have the eagerness to advocate its legal honors to affirm its responsibilities to legitimate sovereignty and the rule of law. The judges' respectful manner to the executive and legislature has been unhindered by the judges' respect for the legislature. They opine that judicial adjudication plays a vital role in upholding the country's justice. Later, reasoned judges should be active in interpreting the new law and interpret the existing law. Judges have to construe Parliament's argument as they have the extent of freedom of making choices and resourceful authority. Usually, the courts would work by the similar principle decisions according to the prior lawmaking and precedents. On the other hand, judges do still make laws. They make laws all the time, and law do authors as other circumstances thrive and grounded on the realistic concept. Therefore, it is to be acknowledged that judicators still enact new statute. All in all, there should always be an equilibrium in the middle of responsibilities of parliaments and the judges to ensure that the process of policy making and the rights to a decisions are utilized wisely. The bigger the authority, the more uncertain it is. Thank you, Doctor.